Okay, as mentioned earlier, this is review for exam one. Make sure you have good, stable internet connection. Don't wait until the last day to take the exam or the very last hour. Technology can fail. Things can come up at the last minute. Do your best to answer every question. If you miss or skip a question, it will be marked wrong. Excuse me. Keep an eye on your time. Make sure you submit your exam before the time runs out, or your answers may be lost or may not be accepted if you go past 60 minutes and the system is still going. You have one attempt to do this, so make sure that you do your best. It is open note and open book, so you're welcome to take notes. You're welcome to use your notes, but you cannot use each other. And if you search on the internet, make sure you're careful that you have the right state questions, because different states have different answers. And I've been licensed in 3 states, so I do know that there is differences. There's 150 points, consist of 1 essay with 25 points and 51 multiple choice questions. There may be extra credit at the end of the exam, but if there is, it will be clearly marked extra credit. I'm going to go ahead and get started and show you examples of questions that you will possibly see on the exam. Either these are questions that were written similar to the exam or from your actual quizzes. And so I took some things that people may have missed and wanted to go over them. The right to possess, encumber, use, and enjoy a piece of property to the exclusion of all others would be an accurate description of, and here are several different ones. And think about eliminating questions or answers when you're thinking about this. It could be possibly 2 here, but what are we studying? We're studying real estate, real property, and what is it covering? So go back to your chapter and look at that. The answer is actually in green here. So if you see the answer, you can see that it's actually real property because it's marked green. A liquid, if I can read today, damage clause allows the seller to keep the deposit if the buyer breaches the contract. Basically, when you give a kind of a check at the when you make an offer to like a buyer comes to you and says, I want to buy a property, and the agent says, great, we want to make sure that you're qualified, we want to make sure that you may get pre-approval letter. You may want to make sure that their FICO scores are good. You want to make sure that there are certain things you're going to look at. But those are all great. But in today's market, especially in a seller's market, sellers want some kind of security. If they're going to take their house off the market, what is it they're going to get? Well, they're going to get liquidated damages, and that's in the form of a deposit. So when you get a signed around, agreed upon, seller and buyer agree upon a price and terms, and both agree, then escrow is open and the buyer's earnest money check is deposited in there. And that's so if the buyer doesn't deliver or they breach the contract, the sellers get to keep that. In theory, anyway. That doesn't always happen, but it certainly will cause a lot of grief. But for the answer for your test, as well as the state test, you want to make sure that you mark the correct answer. Which is not an option of the seller when receiving an offer? which is not. So you need to pay attention to the question. When you see the question, don't instantly just respond to it. Look at the words not, maybe. The cues that you would do for a multiple choice question. And in this case, which is not an option of the seller when receiving an offer. Well, you might think that respond would be a dumb answer or not really a correct answer. But by not responding is the answer. In other words, if a seller doesn't accept it, it's still a answer. They rejected it. So by not replying to the buyers, it's still in the contract. It says that within 3 business days or within 3 days or however many days, if they haven't responded, that is your answer. So it in this case, it is a response. And so that's something to think about here. And you might want to go back and look at it in the book, but that is a question that I've had in the past. Number 4. The misappropriation and use of clients' funds by an agent is called. And commingling and conversion, they're often confused. Commingling means that maybe somebody put their personal money into, or the client's money into the wrong account, like their own personal account, or maybe they put their earnest money check into their wallet. That would be also considered commingling. And misappropriation of funds is conversion, if I can talk it all, but the answer is in green here. If you have any questions, please feel free to go ahead and pop in. According to real estate license law, for supervisors' purposes, the relationship between a salesperson and his broker. Although most real estate agents and brokers or agents working for a broker are independent contractors, it is more of an employer and employee connection. Your broker is responsible for you, and you are accountable to him, even though you're working as an independent contractor. So on the state test, this question had shown up for me, and it may still be there. And so this is the relationship when you're thinking about it. Even though you have a private independent contractors agreement, it's more of an employer and employee situation. Number 6. Who is not accepted from completing a transfer disclosure statement. And once again, make sure you read who is not. Make sure that it's really comes to, be careful with the words, okay? Because otherwise you would get it wrong immediately. And in this case, who is not a seller with in a probate? If they've never lived there, they haven't owned the property, it could be a lawyer that's handling the property, they wouldn't have an idea of what the condition of that property would be. So they wouldn't do a TDS is our term that we use, but it's transfer disclosure statement. A seller of a small commercial property, any commercial property currently does not have to take and do the TDS. There may be similar forms, but it's not called a transfer disclosure statement. A seller with a vacant land, there's no building on it, so wouldn't apply here. However, a unit of anywhere from 1 to 4 units is considered residential. Therefore, they would need to fill it out. And so in this case, who is not exempted would be the unit of 4, an apartment building of 4 units. 7, an owner lists a home for sale with XYZ Realty with instructors to submit the listing to the multiple listing service and invites other brokers to help find a buyer. This is an example of, and then there's several different ones here. And make sure that you understand what dual agency is. You will need to know that. But in this case, it's offer to cooperate. Some people put dual agency, but they confuse the definition of dual agency. So make sure you know what dual agency is. In this case, one broker is putting it in the MLS. They have this exclusive right to sell it, but they put it out there and say, if your agent or any agent working for another broker brings a buyer, then they'll get a percentage for bringing that buyer. Excuse me, like I said, I have a really bad cold. So make sure that you pay close attention to that. And dual agency is if your broker represents both the buyer and seller. Sometimes an agent can do both sides of the transaction, but understand dual agency is the broker. So if a broker has 2 agents in the same brokerage, and it's the same broker that's responsible for the 2 agents, then that's considered dual agency, and that's really important to understand. So it could be 2 separate agents in the same office, or different offices, but one broker is responsible for maybe multiple offices. Then it's still considered dual agency, because the broker is ultimately responsible, and the seller or the buyer, the broker's, if you're representing the buyer and a seller, then you may be an agent that's representing both sides, but the broker is ultimately responsible, and it's the broker that has the client, even though you're working with the client. And so therefore, if you have an agent X in the same office or across town, and there's another office, but the broker is responsible for both offices, once again, that's considered dual agency. And please double check that and make sure you understand it, because that will come up not only in this exam, but your state exam, and probably, I know for a fact, it'll be in your final, as well as another exam possibly. So make sure you're understanding that. Okay, those were the questions I can think of for the exam for questions. Now let's go through some of the questions that were in the quiz that several people may have missed or may have not understood. So quiz 3, an agency may not be terminated by 1, death, agreement, estoppel, expiration. Okay. And lots of people may have chosen, and it said any agency may not be terminated by. And at first it may seem like one answer over the other stands out, but the answer is not. And you would think death. Why, if somebody dies, then obviously that should break the contract. That is not necessarily the case, and here's why. If you, as an agent, sign a contract with a seller, and a seller, say it was a one person that owned the house, so Joe Smith owned the house. Nobody else owned the house. Well, he had the listing already, and you're like, okay, well, Joe passed away. There's no wife, no additional persons, but their heirs may want to continue that contract, and therefore, because Joe Smith happened to already sign this contract with you, you accepted it. Your broker and you are responsible for carrying out the requirements for the heirs. Or if there's a wife, would also be the case. If she wanted to proceed and maybe she wasn't on the contract and maybe she wasn't on the title, but now she's the heir, she can also insist that you continue the contract. It also had come up with a court case where maybe somebody had passed away. They had signed the contract that they were going to sell the house. The owner did, and then they passed away. But before the close of escrow, the person passed away. Well, what happens with that contract? Well, the buyers can insist that you close the deal, even if the heirs want to not do it. So, and then in that case, you're still representing the family or individual that represents the house. So in the case of a death, there's where a couple of examples of where your agency would not be terminated right away. Okay, a broker may act as a dual agent in a sales transaction provided. If I can read, like I said, may act as a dual agent in a sales transaction provided. Okay, there are several different answers here. The buyer and seller have agreed to it in writing. So if you don't have written authorization, you cannot act as a dual agent. In other words, you can't represent both the buyer and seller. A seller could say, yeah, I want you to represent me, but I don't want you to represent a seller or a buyer. But understand, that doesn't mean just the agent, and that actually applies to the entire brokerage. So in other words, if a seller says, I want you to represent me, and doesn't sign the dual agency, your broker and everyone that works under that broker cannot bring a buyer. And that needs to be disclosed to the seller that it's the broker that you have a contract with and you're representing them. And there are brokerages that only represent one side or another. And brokerages means like the entire office or offices. Excuse me. So be aware of that. But the biggest important part here is you have to have it in writing. It has to be disclosed and it has to be in writing, but definitely in writing. All right. Disclosures regarding real estate agency relationships form must be signed at the time of agency appointment. So, if a seller thinks that you're just representing them, and then you bring a buyer or another person from the office brings a buyer, they could be, they need to be disclosed up front and they need to be aware of it. And you can give them all the answers and all the options, and they can even change their mind after the fact, but you need to make sure that everything's up front and in writing. So you need to be aware of that. So here's examples of that. Here's another type of question with the death in a property. And I had lots of people last year miss this question, so I decided to go ahead and add it to the review. So if you're watching this review, you probably have this on the exam or something very similar to it, so make sure you pay attention. A death in a property must be disclosed if it affects the value and occurred within the last 3 years. In the book, it'll talk about the last 3 years, but it also, and doesn't necessarily point it out very well, but anything that affects the value of the property also has to be disclosed. So yes, if it's occurred in the last 3 years, yes, you absolutely do. But if it occurred like 4 years ago or 5 years ago, and say you have some religions or some ethnic groups may not want to live in a house that anybody's died in, whether it's natural causes or not. If that affects their opinion of the value of the property, or they wouldn't have paid as much because maybe they want to rent that house out, but now they're not going to get good tenants in there because they may live in an area, that house may be in an area where people believe things. Go ahead and Jacqueline, go ahead and mute your phone. And so if you can, go ahead and mute your phone, and I'll finish up here, and then I'll answer any questions. Okay, so in this case, make sure that anything that affects the value, as well as death within the last 3 years. So if value is not in there, then for sure the last 3 years. So you want to pay attention to the question as well as the answer. The best form of selling, the best form for a seller to disclose a roof leak would be. This was on one of your questions, and lots of people miss this as well. This is highly important. An agent will disclose it on the agent visible inspection, or AVID is what we call it. But a seller, in this case it's a seller, will disclose it on their transfer disclosure statement. And it's really important that agents don't ever fill out the transfer disclosure statement or follow the rules of your broker. There are rare exceptions to that, but always follow the rules of your broker. But in the exam question and on the state exam, this would be the answer, transfer disclosure statement for a seller. If it's an agent, it would be agent visible inspection. So this question could be asked 2 different ways, and the answer could be different depending on the question. So once again, double check the question and the answers. Read it thoroughly. And in quiz 5, there was a few that missed this one, so I thought I would go ahead and address this. Per car purchase contract or agreement, a seller may accept an offer within 3 days following the buyer's signature, within 3 days following presentation, any following presentation, or any time prior to presentation. So basically, you can't do it here, so that should be eliminated. If they're not presented with the offer, then how would they even know? In other words, if you haven't told them verbally or in written form, how are they ever going to see the answer or the offer? So they haven't been presented the offer, whether it's verbally or any other way. So that can't be the answer. Within 3 days following they can do it with any time that's on the contract. Now 3 days is in the contract language. However, there's always a blank, so it could be like 5 days if they want to extend it, or 6 days. But as far as on the contract itself, this is how it's written. So if the agent hasn't put in there 5 days or 6 days or whatever, then this is the default answer. And anytime following presentation, well, they could do it anytime 3 days or sooner. It doesn't have to be on the 3rd day. So you just have to read the question and really just kind of think through the process. So I hope that this gave you a basic understanding that the types of questions, the quiz questions that we've had will be very similar to the ones you've seen, the structure of it. You may see one question at a time. You may see multiple questions at a time. But the types of questions you see, you should, for the multiple choice, will be very similar to what you have here and have seen on the quizzes. And I hope this helps you, and I'm going to go ahead and stop the video. So if you have questions, I could address any of those that are with me here.